in terms of the whole COVID, in terms of the whole COVID experience. As Shay and Jasmine and I were just talking, I think a couple of you probably knew I was out for a while for some personal surgery that had to take place, but I'm back. So that kind of happened during the whole COVID thing, which was interesting in and of itself. But all things have changed so quickly with respect to how we do our business now that it's been remarkable. So since the end of March, when it was originally determined that we, meaning we in the real estate business, were essential, right? There was questions. Are we essential? Are we not essential? Maryland Association of Realtors, National Association of Realtors, everybody was laying out different ideas or plans as to how we were going to conduct business. What were we going to do with respect to contracts and process, showing properties, listing properties? Well, the dust settled and we were deemed across the board to be essential businesses. And that included mortgage, that included, which is of course Mr. Cooper and company, that included title, Velocity National Title, that included law and real estate professionals. So we kind of breathed a sigh of relief at that point because there was a lot of questions as to whether or not we were going to be able to continue to earn a living and support our customers and clients. But here we are a number of months later, and pardon me, let me turn my phone down here, guys. Here we are a couple of months later, and holy smokes, right? What the heck happened? Interest rates fell into the twos generally, and we are busier than we could imagine. If you're listing property, you know that if you put a sign in the yard, you're lucky. Most of the properties are getting out of the off the market and sold by the time the first showing is ready to be scheduled. So that's a good thing in terms of being a seller's market, appreciating home values, making real estate professionals more money, and keeping you active. Newer agents, if there's a new group of agents on this Zoom meeting, take this to heart. Right now, you can make a name for yourself so fast, being out and being present in the marketplace, taking listings, because they're going to sell. You're going to get quick sales, and people are going to love you, right? You're going to get a buildup of a lot of support from your customer client base, and get them to come back with a great referral and recommendation for you. Exploit the good market to the best of your ability right now to make your name as known as possible and get people to put something on their Facebooks or whatever other social media that they're using about how good of a job that you did. Get out in the marketplace as much as possible right now, because this market is an unusual market. Some of the economists in the real estate world nationally are saying we're going to look at this market for 18 to 24 months. So if we're in the twos for 18 to 24 months with no interest rate hike in sight, this is going to be a wonderful dynamic time to make a statement in the real estate business, which leads to what we're talking about today, right? Exclusive right to sell.
Yes, it does.
Residential brokerage agreement, right? If you are a real estate professional, this exclusive right to sell residential brokerage agreement, commonly referred to as a listing agreement, it is your Bible. It is the contract of choice. It is what you want in hand at all times. You want to know this contract inside and out. So when we're together and I'm teaching, I love interaction, right? Interaction, back and forth, talk, conversation. What does this mean? What does that mean? It's very difficult to do in this environment. So instead of having as much interaction, we are having more of a, I'm talking to you. I don't want it to come across as talking at you, but talking to you. Soon we'll be back. When they let us come back, if we want, we can do this, in a broader space where we can wear masks or whatever everybody's comfortable with and do it in a face-to-face environment. I think our teaching success is better served when we are interacting with each other. But that being said, let's get to the meat of this course today, which is the listing agreement. And when you're looking at a listing agreement, you understand one thing. This is a service contract. It's a contract, which means, of course, contract terms legally are terms expressed in a written agreement or expressed in an oral agreement, that the parties have a meeting of the mind, and that if there's an interpretation to the document that needs to be reviewed by a court, that the court is going to look to, or the real estate commission for that matter, is going to look to the four corners of the document. So let's get into it. Page 1 of this agreement is going to outline some very essential terms, some very essential information. And one of the things that I've found over the years where people have gotten themselves in trouble is they don't have all of the information properly entered in the listing agreement. There's pieces missing. They say, the seller might say, oh, well, I don't have this information right now. I'll get back to you on that. And then it never gets followed up. And that becomes problematic if something happens down the road. One of the most important things in a service contract agreement is to understand that if you have a contract that has terms, right? Paragraph 4, listing term, rights of the parties. And it has terms for a specific date, right? Effective date, you see that? And termination date. That is, how long is this agreement in place? So the question always comes up, well, I have a contract, let's just say October the 1st, and we're going to go out 6 months, right? And we're going to say April 1st or March 31st. It's going to terminate on March 31st, the end of March. You've got a 6-month agreement, but a seller wants to terminate that agreement 30 days into it. Does a seller have an absolute right to terminate the agreement 30 days into it, even though your listing agreement says March? And the answer to the question is absolutely yes. It is a service contract. What does that mean? It means that until the service is performed, a seller or a party to the contract can terminate the requested performance and pay nothing. Now, one of the things that's important, that the full information relating to the parties is entered. And it's really simple. You see it at 1 and 2. Who's the seller? Who's the broker? The seller, commonly in legal terms, is the principal. The principal, the person who controls what the agent for the seller is, who is the broker, is going to be doing. And this listing agreement spells that out. So it's important that you enter the date of the agreement, which may not be, by the way, the effective date of the listing, but it's the date in which the parties signed the agreement. The seller, again, is your principal. All of the information, the contact information needs to be in there. It is a requirement that the broker's information be in this agreement at all times. That's a real estate commission requirement. All of that information needs to be on there. You cannot omit an office telephone for the broker. So it's the broker's name, not your name as the agent, the broker's name, the address, and the office telephone number must be on there. The listing agent is the agent for the broker. That's you in taking the listing. 3 is very self-explanatory, right? The property listing, right? The under 3, it's going to be the broker is authorized to undertake some authority on behalf of a seller, and that is to sell or lease a piece of real estate that the seller actually is entitled to. So this is one of the things I want to get to in reference to when I teach these listing courses. When you're taking a listing from somebody and you're going to go out there and you've got your listing agreement, there's a couple of things that a lot of agents miss. And that number one thing is confirming that the individual with whom you're meeting, maybe at the house or maybe somewhere else, is in fact the owner or all of the owners. The most frequent problem I run into, or people run into that come to see me about cases, is a husband and wife going through a divorce, and the real estate agent meets only with one of the parties, and only one of the parties signs the listing agreement. So then if we were together, one of my questions would be at this point in time, if you meet with the husband and the husband signs the listing agreement, do you have a valid listing agreement? And you put the property in the MLS, you get a contract, etc. Do we have a valid listing agreement, number one? And do we have a valid contract, number 2? And the answer to both questions is no. All parties entitled to the property, all owners of the property must be entitled and must be on this listing agreement. All parties entitled must execute and sign the authority to sell a property. So we were talking about title insurance once before, and there was a case that I handled many years ago in Montgomery County, and it relates to listing agreement and title claim. And it's worthy, the case is such a big case, it's worthy of bringing back up and giving the example of where a real estate agent really fell into a tremendous amount of hot water for tens of millions of dollars. The real estate agent gets a call to list a farm, and this is in the early 1970s. You're going to list a farm in Montgomery County, and it's a rather large tract of land. The listing agent is remarkably excited because he's going to be able to list this tract of land. It's going to be millions of dollars, and there's going to be a huge commission. Listing agent takes the listing. There's a developer that wants to buy this parcel and subdivide. So the developer comes along, and the husband had signed the listing agreement without the wife, but in fact had his girlfriend execute the documents, the listing document, as well as this contract of sale, as well as the settlement documents. There's a lot of problems a lot of mistakes that people made that created a lot of problems in this transaction. But one of the things was a simple thing. None of the parties, not the listing agent nor the title agent at that time, took valid identification from the parties. Now, back in the 70s, there was no picture identification for driver's licenses. They were paper versions of identification, but nonetheless, they did have paper versions that were usually collected at the time, as well as credit cards or other identification documents. None of that was secured in this transaction. Well, ultimately, of course, the ex-wife of this farmer passed away, and the estate attorneys filed suit after years and years and years against all of the 200, I think it was 204 if my memory is correct, 204 property owners after that property was subdivided and sold by the developer to people. Well, it was a suit for many, many, many millions of dollars. And of course, who's brought into the suit? The broker, because they sold a property without the lawful seller signing the listing agreement. They did nothing to confirm who owned the property. And it was an errors and omissions claim, so the insurance company had to pay out many millions of dollars. The title insurance company paid out many millions of dollars, and the case was ultimately resolved. But you do not want to be the agent who gets named in a lawsuit for failure to identify the party with whom you are working and then confirm that they in fact own the property. You know, most of the agents that I ask, when you take a listing agreement, do you get a copy of the driver's licenses of the parties with whom you're getting the listing? If you don't know them, if this is a first impression, and you don't know those individuals, are you just basically saying to the client, hey, can we get a copy of your driver's license, please put it in the file? We have to have that. Lenders are going to need it. Title people are going to need it. We need to confirm that. It's a simple question. Most people are readily willing to provide an identification, a copy of a driver's license when you're in legal transactions. You're conducting basic due diligence by doing that, and you're confirming that you're taking a listing and selling a property that you have confirmed who the owners are. Now, how are you going to confirm who the owners are, right? You take a copy of their driver's license. It's John Smith and Sally Smith. So John Smith and Sally Smith should be the same individuals' names who are on the SDAT report when you've looked up the property. And if there's any further questions, you can always call Velocity. Somebody at Velocity will do a quick land record search to make sure the deed is current in Sally and John Smith. We're happy to do that for you. And that is what we're going to do anyway once the contract comes over, is we're going to confirm. Today, it is much more difficult to do what happened with the farmer in that example. So when you're taking a listing, yes, there's more communication between the title agency and the real estate professionals to confirm who these parties are. But that's really critically important that you understand you have some basic due diligence due under COMAR to make sure that you are actively marketing a property with the right owner or all of the owners. Don't let one party in a divorce case swindle you or convince you that it's perfectly okay, that there's a court order that my wife or my husband doesn't need to be here or sign it or blah, blah, blah. No, that's not appropriate. If both parties are on title, both parties must sign the listing agreement. If there's a court order, send it to me, I'll review it. It is not appropriate for real estate professionals to interpret court orders. That's practicing law, and that can land you in some hot water on that part. So let's get back to the actual document at hand. So we had just talked about identifying the parties, the broker, what you're authorized to do, and that is sell or lease a particular property. That property has to be identified by address. At paragraph 3, your property is known as, and you're going to identify it as the actual address property. So I came across an interesting case, and with respect to addresses this year. There's an address, let's just call it 123 Main Street, but when you look up SDAT, 123 Main Street actually converged with, let's call it 256 South Street. And they were at the intersection. This lot was at the intersection. So the post office had the address as 123 Main Street, but the SDAT, the State Department of Assessments and Taxation, had the address as 246 South Street. And so we now have a conflict. What are you selling? Well, in that case, you don't have to interpret it. You simply put, and it's come up before, but it is interesting where you have this kind of a scenario where SDAT doesn't reflect the proper street address, is you simply put 123 Main Street, also known as 246 South Street, in the section here, property known as. And then you've covered yourself because you've got both the postal address as well as the State Department record address for purposes of identifying the property that you're actually selling, right? If you don't have something in there, you have no authority. If this is blank or is wrong, you have no lawful authority to sell that particular property. The listing term, we talked about that. We kind of touched on this a little bit before. The listing term, of course, is how long is your listing? When I was selling, I always wanted to get at least a minimum of 6 months. If for nothing else, it's a psychological threshold for your client that they're going to give you a reasonable period of time. And look, in another today's market, you're going to put this property on the MLS if it's so authorized to be on the MLS, and that's down here below. But if it's so authorized to be on the MLS, you'll put it in the MLS, and holy smokes, you're going to have 4 contracts, 5 contracts, escalation clauses, and everything else. But that's not a normal market. In a normal market, you're going to have a scenario where you're going to put time, you're going to put marketing money, resources, brochures, et cetera, et cetera. It's very reasonable to ask your client, look, we need a minimum of 6 months. And maybe, Jasmine, you can chime in here. Do you have a minimum threshold that you like to see listings for the term because of the resources spent by Porterhouse and the agents?
Yes. So the goal is we automatically offer people a year, so 12 months on a listing contract. I would say no less than 6 months.
Good. So they've extended it even past what I was doing, which is a 12-month. And I think that's fair and reasonable. And the reason is because you're spending money. People understand that. You're spending time and money and resources to market their property. And it's a fair consideration, right? That if you're going to spend the time and the money and the resources to put a property on the market for sale, the person who's asking you to do that has to give you the reasonable period of time. And so 12 months is great. I love that. Get a 12-month agreement, right? And get that agreement as long as you possibly can. But I love 12 months, 15 if you can, whatever, to give you the ample time to put in the resources and allocate the time necessary to get that property sold. Now, since I'm talking the legal issues today, people get very upset sometimes when they market a property and the seller pulls the rug out from under them. It says, I'm going to switch, or I'm going to sell, the property somewhere at some other time. I just don't want to keep it on the market, or I'm going to change, whatever they're going to do. So with respect to those times when a seller terminates a listing agreement, they have the lawful right to do so, but under certain conditions. So if you've shown the property to a prospective buyer, then you have the right to compensation. The legal term and what was relied upon for many years in the courts is something called threshold law. Who brought the buyers over the threshold when the buyers executed an offer? So if your property is shown to prospective buyers by, let's just call it a Long and Foster agent shows the property to a prospective buyer. You are the listing agent. Porterhouse is the listing broker. Then the seller decides that they are going to contact the buyer directly because they had a great conversation. They knew some people together, and they have some common friends. And so they hook up in a conversation. And they agree that, heck, we don't need Remax and we don't need Porterhouse. Let's terminate the listing and let's write our own contract, get some lawyer to help us out, and we can avoid paying the huge commission. Buyer, I'll drop the price a little bit so you benefit and I benefit because I don't have to pay the whole commission, et cetera. I can tell you that happens over and over again. Probably on a yearly basis, I get a dozen calls from brokers who say, hey, we had this happen. How do we handle it? Are we entitled to a commission? Is my agent entitled to a commission? And the answer to that is yes. Even if you did not participate in the contract, if that happens, under that example, you are entitled to your compensation. You're entitled to the compensation because you were the listing agent at the time the buyer crossed the threshold. So at that moment, when the buyer writes a contract for this property, the agency relationship is still covered by law, even though the contract itself has been terminated. So if something happens to that effect, call Shay, call Jasmine, call me. We'll help you out. We'll get that done. We'll get that cured, because we will go after commissions for you if people have been, let's just call it unscrupulous, and they've attempted to avoid paying your duly earned fee. And that's what this agreement is all about. Let's face it, right? It's a lot of pages of stuff, and it's all about you doing hard work. And for them to undercut you, sorry, I got no patience for that. We're going to protect your commission. We're going to protect it. Under the law, under Maryland law, a real estate broker's commission is earned, due, and payable, not at settlement, at the time ratified contract. When the broker produces a ready, willing, and able buyer, at that point in time, your commission is earned, due, and payable. So that extends to even if the listing agreement has been terminated, but that same buyer comes back because the broker, in effect, had produced that ready, willing, and able buyer. They were able because they ultimately consummated closing, the settlement. All right, so going down. The 4 has a provision under section 17534B5 of the Maryland Real Estate Brokers Act, right? Well, what's that telling you? It's telling you a couple of things right away. Number one, there's a Brokers Act. If you have not read that provision, shame on you. Get on Google, look it up, Maryland section 17534B5 of the Maryland Brokers Act, and read it, understand what it says, because just like in your contracts of sale, your residential purchase and sale contract, if you don't know what it says, how can you possibly discuss it with your client and advise your client? You got to know what it says. And this is specific to the termination of the agreement, so there can be something written in there, simple, like notice, written notice has to be given by either party, okay? Paragraph 5, listing price. You cannot have it blank. You can't have to be determined, TBD. There must be a listing price in a valid listing agreement. Showing instructions. Showing instructions are very, very important. Let's think about a recent case with regard to showing instructions. Dogs, right? Dogs can bite. Dogs can be aggressive. Dogs can startle. Dogs can cause somebody to be injured, even if their injury is by accident. If the client has a dog, you must have specific showing instructions. You've got to discuss that with your client. You have, as a broker, an obligation to notify in the MLS potential buyers that there's a dog in the property. You have an obligation to contact your seller in advance and make sure that the dog that they have noticed that somebody is coming and when they're coming, and they've noticed to put the dog away. Your actual duty ends there, however, and once you've noted and you have provided those specific instructions to your client, and you put them in the actual listing agreement. At that point in time, your duty ends, and it's on the seller. The seller has the further obligation to ensure that the dog is constrained and to ensure the safety of potential buyers and real estate agents who are showing on that property. So, from that particular perspective, it's on the seller. All you have to do is make sure you note it. Put it in your listing notes, showing notes. Jane from Remax showing the property at 3, notified sellers, notified them of dog. That's it. That's all you have to do. Of course, on paragraph 7 of the listing agreement, you've got to get marketing authority to the MLS. Okay? Marketing authority comes in paragraph 7. And you can see there's something big and bold under paragraph 7. And that big and bold is seller. It's 7B, okay? 7A is, of course, the authorization for the broker to market the property. You can go down the enumerated list, which is broker's internet, website, any other website or social media material. Those kinds of things are implied in either print or internet sources that you have that right to display, unless the seller has specifically elected not to have those types of displays, and that's under 7B. So if you've got a seller who doesn't want that for some reason, then maybe you're going to list Tiger Woods' house, right? Tiger Woods doesn't necessarily want a lot of marketing material out there for whatever reason. He wants it more private. That's what he's going to select, 7B, right? But you've got to have this clear in your mind as to what your responsibility is, and clear this with your clients before. So of course, 7C starts to describe what authorities you have under social media and websites, that kind of thing. You can modify or limit this. Let me ask you a question. Well, I guess we can't do questions. So, can you as the agent, when you're sitting there with your client, modify?
Glenn, you can ask questions. Feel free to ask questions.
Okay. So, can you modify this listing agreement in 7 with your seller to be unique to whatever that particular seller's desires are? So the question is, you're sitting and you're discussing this, and a seller may want to have a mixed bag of what's available. Can you modify, add provisions, an addendum to this, change terms? Can you do that when you're with your clients? That's my question. Anybody can answer if you want to chime in, if you know. And if nobody does, I'll just go to I'll go to the answer in just a second. But if you've listed properties before and you're sitting with your client and they want to modify some of the terms in here, can you do that legally as the agent sitting?
Hey, Glenn, I would say that
Hey, Curtis.
How you doing?
Good, bud. How are you?
I'm doing all right. I would jump out and say that you can't change the document, because it's a legally binding document, but you could probably, like you were saying, add an addendum of some kind of provisions or special requests that the client is looking for.
Okay. Anybody else? Any ideas? Any thoughts? Okay, so Curtis is pretty much dead on. But I'm going to add to it just a little bit. The agent who's meeting with, let me phrase it in a different way. Is there a difference between Curtis changing anything in this document or any of the other agents and Jasmine sitting with a client and changing any of the terms or documents, language in this document? Is there any difference or distinction? One can do it, one cannot.
Well, I would say that Jasmine can't do it either, because if it's a legally binding document, then it was created by, she's not a lawyer, or she's not, that's just what I would assume, is like she can't change anything within the document because it's bound, or it's a legally binding document.
Okay. So it's an interesting question, because agents do run into this from time to time where a seller wants to change something in the document. And the answer to the question is an agent may not change anything in the document, but a broker may change terms in the document. So Curtis is exactly right. It's a legally binding document. The document itself is drafted by attorneys for the Maryland Association of Realtors, right? The language is pre-written, but before it's agreed upon, it is simply a pre-written document. It becomes a legally binding document as soon as the parties execute it, and now it has the force of contract. So prior to the broker signing this listing agreement and the seller signing it, either party may change terms within the agreement, just as you would change terms in a contract of sale. You can do cross-throughs, you can do addendums of whatever. But if there's some special thing that the real estate client wants, the seller, you can do that exactly as Curtis said by adding an addendum. If the seller demands, right, it's a multi-million-dollar listing, the seller demands, I want a television commercial to air every Sunday morning at 10 a.m. on, station X. Well, that's not really in this listing agreement. So they would do an addendum. And if the broker agrees, then it's binding. If they want to strike a provision in here, the seller can just line item right through it, strike it, put his initials there. The broker, Jasmine, would have to sign an initial as well, but we do not have a final ratified agreement between the parties. But they could if they wanted to. So if there's something that you're going through this document with your client, I don't recommend you offer up changes to the document, because it is thoughtfully written as a contract, generally to protect real estate professionals, quite frankly. That these contracts are drafted in a way that they're fairly drafted, but they do have protections for real estate professionals. So as soon as you start to tweak them a little bit, you better know what you're doing. And so, as Curtis said, you don't want to necessarily be practicing law. So maybe Jasmine would want to call me and we would talk about the language that the client wants in the agreement before it gets actually changed. So, and then we would draft the appropriate language to effectuate exactly what the parties want, what the broker's agreeing to do, and what the seller wants. So it's an interesting idea that you can change some of the terms in here, but if you do so, you want to do so very judiciously, very cautiously. You want to make sure that, number one, the agent is not able to change the terms here. Only the broker and the seller can. So, and that begs the question, right? Who is the seller signing this agreement with? The agent or the broker? Who has the value rights, if you will, to this agreement, the agent or the broker? Well, the answer, of course, is the broker. The agent works for the principal, the broker, and the principal, in this case, the real estate broker, works as an agent for the other principal, the owner of the property, the seller. And hopefully that makes sense to everybody. And I'm open to questions and things as well. So the answer to that is, when you're going through your marketing stuff with people, yes, you can modify, you can change, you can do that, but do it cautiously. If they want something special, you call up Jasmine. If she wants to get some language from me, we can do that. You know, turning on to a 7E, of course, coming soon listing. And if you do a coming soon listing today, you're going to get 1,000 calls, right? You know, but this contemplates that a seller may want to do that. So it gives you, this meaning the listing agreement, gives some flexibility in that arena, okay? Everybody knows when you go to a doctor, you have to get informed consent from the doctor. The doctor has to keep all of your information private. There's privacy concerns, and the same rule applies to you as a listing agent with your client. You must have consent, informed consent to discuss anything. And you know, paragraph 8 really refers to discussing other properties with prospective buyers, but the rule applies. Anything about your listing with anyone other than your seller, right? That you must have consent. You have information about your seller, about their motives, what they're willing to accept in price, how quickly they want to move. Well, those terms are negotiable terms that are not to be broadcast or disclosed to potential buyers. Let's just say you have a transaction, you have a listing, and it has a contract on it. In the original contract, $300,000 even, your sellers bought it. You had the house listed at $315,000. Your seller signed the contract, I mean. So something happens in the home inspection, the contract falls through. Now you've got it back on the market again. An agent calls up and says, well, I knew you'd taken it off the market before. You must have had another contract. Hey, will you let me know what that contract was so I can guide my buyers that are really interested? Disclosing that information would land you in a lot of hot water. You can't disclose what your seller is willing to accept without your seller's written, not verbal, written permission. So any terms your sellers are willing to accept, you know, 8 and 9 really talks about data, information, disclosure, publications, those kind of things. And you don't want to get yourself caught up in a scenario where you've disclosed improperly information about your seller's motives, time schedule, available price determination, that kind of thing. So let's talk about home security systems for a second. it's important that you understand there's a law in Maryland, right? And your sellers are obligated to this, and you're obligated to this. And it became a common knowledge law, but people have forgotten about it. But if you go back to the Monica Lewinsky case and President Clinton, the blue dress, the woman from Columbia, Maryland, I forget her name right this minute. If anybody remembers it, yell out. Linda something. But it is illegal in Maryland to audio record anyone without their knowledge, and it carries a 5-year penalty in jail. So with today's technology, it's easy to record people in the house through security systems or other type recording devices. Interestingly, it's not illegal to video somebody without their knowledge. But the audio portion is actually illegal. So you want to be very, very careful. You want to bring this to the attention of your sellers to let them know that, hey, can't do it. People want to do it. They want to hear what the buyers are saying about their house. They want to hear about, hey, does the house look good? Does the house look bad? Is it overpriced? Is it underpriced? What the parties are thinking about. Don't let them do that. If you know that they have a system, even if it's one of those Ring systems or other recording type devices, if you're marketing your home for sale, cannot allow the recording device, the audio recording device, to be activated. Paragraph 11. We'll move on to paragraph 11, fair housing. This is a cornerstone piece of opening housing to everyone in our community, in our society, and it should go without saying that every single person who's involved in real estate understands the concept of what fair housing means. Most of the people that I've met at Porterhouse were not born in 1968 and didn't live through that period of time, but I was a young person at that time, and this was a critically important piece of legislation in moving us forward to a place where everyone could enjoy what I think is one of the most valuable and critical pieces of living in a free society, is being able to own your own little piece of the world. And that right belongs to every free human being to be able to buy a piece of property. So it cannot be understated that in every transaction, that in every bit of conduct that you are participating in your profession, that you uphold that fundamental cornerstone, the underpinning of what it means to provide a part of a fair housing transaction. And every transaction, no matter who the parties are, where they're from, needs to be supported by every real estate professional. That is the way we do business, period, full stop. That's all. Seller's responsibility on insurance, particularly. Number 12. Contract, sellers often mess this up. It doesn't happen much, but it does. They cut off their insurance on the premises prematurely. And one of the problems that happens is if you cut off your insurance prematurely, you can't get it back. In other words, if you terminate the insurance policy 15 days prior to settlement, and you go back and try and get it reactivated, most insurance companies will decline that policy. And that's a critically important thing that the sellers be made aware of. Do not terminate your policy until settlement date. Because if something happens, a flood, electrical fire, whatever, the seller's going to be responsible. And if they've terminated their insurance prematurely, well, it's on them, but they're going to look to you and they're going to say, what, you guys didn't tell me about that. So hopefully in your checklist, you've got a little note to your sellers. Do not terminate your insurance policy prior to settlement. Prior to settlement. So just a little side note to keep in your listing notes to make sure that you've provided that written notification to your sellers about that. That's going to be critically important should something happen and everybody wants to point fingers. Repairs is number 13, and then we're going to get to number 14, which is, of course, what you're working for. But number 13. So sellers do this a lot. You get a home inspection. Seller says, "Oh, I got my buddy. He's a fix-it man, and he can fix all of these things, right? And he works for ABC contractors." The problem is ABC Contractors is duly licensed, but my buddy Jim is not duly licensed. He's an employee for ABC Contractor. He goes out and he does work and stuff, but he does it under their license. If there's a repair that needs to be made pursuant to a home inspection for which your seller has agreed to make that repair, the party must be a duly licensed contractor unless the buyer and the seller have agreed in writing that the seller can do the repair themselves or have somebody who is a non-licensed party. So in other words, if the parties agree, if the seller says, look, my buddy here works for ABC Contractors, but he's personally not licensed but does all the work, I'd rather have him do it, it's going to save me a lot of money, and the buyer says, okay, fine, no problem. You want an addendum to the contract to that effect, but you can do it, okay? That's fine. The problem lies that sellers generally do, a lot of times do the work themselves. They're not proficient at it, particularly if it's a electrical, if your seller's doing electrical repairs themselves subsequent to a home inspection, well, they're a fool because something happens down the road. They've got real liability, so they want to be very careful with that. So, broker's compensation. Earlier, we talked about what the law provides. So, this is now spelled out in the listing agreements, right? In the event of sale, exchange, or transfer. So those are three different things, right? Why not just say sale? Exchange or transfer are added because properties can be exchanged through different mechanisms. We can do actual exchanges, meaning, hey, I've got a property in the mountains, you've got a property at the beach. I've always wanted to be at the beach. I've lived here in the mountains long enough. You now want to be in the mountains because you've lived at the beach long enough. Why don't we just exchange properties? They're about the same value. Well, if that happens, are you entitled to, all they do is a deed, changing for zero consideration, right? No sales price. They exchange properties. I doubt anybody's ever had that example. I've done a handful of them in my career where people say, we want to exchange our properties without a sales price, without compensation. Are you entitled to that? Well, yes, you are. You're entitled to compensation if they've hired you and there's an exchange, you're entitled to compensation based on the actual listing price. When is the broker earned their compensation? When is it due and payable? Well, a little I, right? When you produce a ready, willing, and able buyer. When you produce that ready, willing, and able buyer, you've earned it. That means that if the deal falls apart later, guess what? You may be still entitled, and likely still are entitled to compensation for your commission, even if it doesn't close. So a seller can find themselves in a situation where they may owe 2 brokers commission, because maybe you've produced a ready, willing, and able buyer, deal falls apart. For some reason, that is, the seller just decides they're not going to sell. Well, guess what? The seller owes you a commission at that point in time. Well, then a month later, the seller decides they're going to put the house back on the market, and they sell it to somebody else with it through another broker. Well, they owe that broker and they owe you for the first contract. So now that seller's gotten themselves into a position where they owe 2 brokerage commissions for a sale. So that was really foolish on their part. And I have handled many of those cases over the years where I've sued sellers for brokers. And in 100% of the cases, we have prevailed, where the broker has produced a ready, willing, and able buyer, and the seller has had to pay the broker's compensation. You don't work for free, and it's actually kind of rude that people would think you do. This is a business, and it's a professional business, and you take it that way, and you should demand the same respect from your clients, that it's a professional business, and when you've performed your service of providing that buyer to them, they owe you the money for it. It's not easy. It's not an easy job. If you go down to the next page and you look at seller breaches and that kind of thing, or buyer breaches under B and C, and then you look at deposits. This happens a little more frequently. So where you have a transaction that's fallen apart and the parties have gone into dispute, right? And there's a $5,000 earnest money deposit. When that happens, we got a question from somebody. I'm going to answer that in just a second. When that happens, the broker is entitled generally under this provision, if it's executed properly, to a percent of the escrow deposit. Now, one of the things that happens quite frequently is the escrow deposit is too small. $1,000. See it all the time. $1,000. Well, that's easy because it motivates a buyer to write on a piece of property, but at the same time, it's too small for your seller in the event of a breach of contract by the buyer. If the seller is going to go after the $1,000, well, that's not paying anybody. In order to pay the damn lawyers on that, that's just too much. That's too little. So it becomes something of a frustration more than anything else. I want to go back to a question somebody just had in reference to the audio recording. When you're in the property, and the question was, can you get a waiver or a release signed by parties going into the property on the way of being recorded? And the answer is yes, but it must be by any person, or every person, let me say, who's in the property at the time of a recording. You could have a waiver release that just says all parties understand and acknowledge that they may be being recorded by security devices within this property at the time they enter. Of course, you should have security system in the actual listing agreement. What I'd like to see them say is recordable security system in the MLS under the security system. I don't think that's happened yet. Somebody could correct me if I'm wrong. I haven't looked at an MLS in data entry in a long time. But what I would like to see the language is it says recordable security system, so that everybody knows when they're walking into that house that there's a recordable security system. And by their agreement to enter the house at all, they understand they may be being recorded. I think that all listing documents and MLS disclosures to buyers should have that when somebody has a recordable security system, which will help avoid this problem. I think in today's world, if you think you have privacy when you walk in somewhere, you don't. If you're in somebody else's house, hopefully you're smart enough to understand that you may be being recorded with the technology available today, whether it's from cell phone technology or from a security technology. But nonetheless, it's still the law in Maryland. The law has not caught up. So the answer to the question is yes, you can have a waiver or disclosure statement that provides you some protection with respect to somebody being recorded. As you well know, probably from hearing it 1,000 times, when you are on the telephone with somebody and you hear this call is being or may be being recorded, at that point in time, you can hang up. Or if you get on the phone, you acknowledge that you're accepting being recorded. So that was a great question. Getting back to the listing agreements, paragraph 15, authority to cooperate with other brokers. Of course, this is just an authority to cooperate. And what is the compensation going to be to other brokers? If you're looking at paragraph 15 under authority, you have some blanks to fill in. Sub-agency, if it's related to the transaction, what is that going to be, if any? And what's the broker co-op going to be? Meaning, how much are you agreeing to pay to the other broker? Could you have a listing where you get 4% and the showing a total compensation of 6%? You get 4, and the buyer's co-op is 2. Anybody can answer that. Is that allowable in Maryland to have 4% to the listing, 2% co-op through a buyer's agent? All right, I'll jump in. There you go, Curtis. Go ahead, bud.
So was that 4% for the listing agent and then 2% for the buying agent?
Yes.
And you're asking if you can do that?
Yes.
Yes. If they agree to it and you know.
Right. Yes, Curtis, you're exactly right. Yes, you can. It could be anything. You could agree to a 10% listing total brokerage fee, 10% of the sales price, and you could take 8 and co-op it 2. No problem. That's the terms. They just have to be written. What is your agreement with your co-op? Where is that agreement found that binds the agents as to the co-op? Between agents, right? So where is a contractual agreement between brokerages found as to what the co-op is going to be?
Would it be in the listing, like on the MLS?
Bingo. Yeah. MLS. The
Woo-hoo.
MLS is actually good answer. The MLS is actually contractual between brokers. When you enter when you sign on to the MLS, you sign on to being contractually bound to whatever's in the MLS. So if you accidentally put 3 and 3 and you meant 2.5 and 2.5, and the broker shows it, and then you find you did that, oops, my admin entered it at 3 and it should have been 2.5. You go back and you change it before the contract comes in. You change it back to 2.5, right? So you don't have a contract yet, but for half an hour, whatever it was, the MLS said 3. And now you've changed it to 2.5. The very next day you get a contract. and the broker is looking for 3%. And you say, well, wait a minute. We've got this in the MLS at 2.5. And they pull out a printout that they pulled off the MLS 5 minutes after you put it in that said 3. What are you obligated to pay, the 2.5 or the 3? And I'll go back to the facts just again real quick. You changed it to the 2.5 before the contract was submitted. But the showing broker, buyer broker, has an MLS printout at 3 because they pulled it off. They were watching that when it was on their hot list. And when anything came up in that neighborhood, they got a note, they pulled the MLS on it. What are you obligated to pay? Anybody? Take a guess.
I would say, hey, Glenn, this is Matthew.
Hey, Matthew, how are you, buddy?
Doing good, doing good. I would say you're liable to pay the 3. I'm just thinking in terms of like, and I've seen this happen before, like, you know, people go to grocery stores and stuff and, you know, certain prices, you know, let's say you'll find an item, but it has the wrong price on it. And, you know, you can go to the front, the manager and say, hey, you know, the manager might say, hey, the price was this, but you can, you know, correct them and say, well, this is the price that you had. And most of the time they'll just go ahead and say, well, you know, we'll just give you the price that it was listed under. So I'm just taking a wild guess and say you go with the 3 on this one.
All right, your legal analysis was spot on. Right? Yeah.
Awesome.
Yeah. Well, I mean, and look, that's great. That's great, you know, out of the box thinking, because your example of the grocery store, the manager's not giving that lower price to the person because they're just want the customer back. It's the law. That's law. The same law, the same rule applies to your world in disclosure of the compensation agreement. What's going to be paid or what's being charged. It's the same rule. So that was great legal analysis. That was great real world interpretation to what you're doing. And the answer was correct, 3%. As soon as that agent printed out the MLS and had it at 3%, that established a contract between the listing agent, the listing broker, and the buyer's broker. And the compensation is going to be 3%. To everybody else in the world who prints it out after the 2.5% change, it's 2.5%. But if anybody out there printed out a 3%er, you pay the 3. So it's whatever MLS that agent is working with, regardless of the fact that it was a mistake. That is what you're going to pay. So that was a great real world analysis there and application to what you do. Ministerial acts. So ministerial acts. What's a ministerial act? Anybody give me an example of a ministerial act that you may have done for your clients as a listing agent? Happens a lot. And it's interesting, the language in this. It says, as defined by law. What do you mean? What do they mean, ministerial acts as defined by law? Right? You know, they throw all these legalese in there, and you know, the interpretation of those legalese. What is where do you find ministerial acts as defined by law, right? So there's a lot of case law about this. a ministerial act for listing agent would be something very simple, like contacting the HOA and securing HOA documents, right? Technically, the seller should do that. They have the contractual relationship and the obligations and duties to the homeowners association and the contractual relationship with the buyer to provide the documents. It's not a listing agent's duty to do those ministerial acts, but many listing agents do it as a convenience. They discuss closing with the title agencies. They help coordinate dates and times for walkthroughs and for home inspections and appraisals. All of those things are not your duty. Anything past a contract of sale is no longer a duty. You have no legal obligation to make sure settlement occurs. Your agreement is to produce a ready, willing, and able buyer. You've done that. You could walk away. Now, why do agents not walk away and, say, okay, here's the contract, sign it, I'll see you when my check is ready? Why do agents not do that? And the answer is a practical one. It's not a legal one, because the damn thing would fall apart between that time and settlement. Too many things to do. Oh God, we got a home inspection. We got a wood destroying insect inspection. We got an appraisal. Maybe I want to make sure I'm there with the appraiser on the date of the appraisal. We have coordinating time and closing. There's issues that the buyer might have to change relating to, repair requests. The million different things that can happen between the date that the contract is signed and the date of settlement. And so agents want to make sure they keep that transaction moving slowly. But lawfully, legally, your obligations to get the transaction to the settlement table terminate at the time you've produced your ready, willing, and able buyer and the seller has signed the agreement consenting to the price and terms. Ministerial acts are authorities granted to you by the principal, the seller, so that you can help coordinate those types of duties, those types of things, not duties, those types of things to get accomplished. So we have that scenario where, you may have to call termite people. You may have to call meet appraisers and home inspectors, et cetera, et cetera. And to do those types of things, your sellers at work, your sellers are doing other things, and they're granting you the authority to do that. And you're acting under that authority. Deposits are a big thing, right? For a long time, there was a big move to have deposits held by title companies before there was actual legal documents and authorities granted by the Maryland Insurance Administration for title companies to actually hold these deposits. Then the Maryland Insurance Administration set out guidelines on holding deposits and having a separate escrow agreement, et cetera, when that happens. So what the brokers were wanting to do was say, we don't want the liability when there's a dispute, and then we have to hire a lawyer to file a bill of interpleader. We have to have this escrow account. We have to manage the escrow account. We have to reconcile it monthly. We have all these issues and responsibilities and tie these escrows to each individual case, et cetera. And so it was a little bit of a problem for brokers. And so many of the brokers decided that they really wanted to start changing and not holding any escrow money. And I kind of raised a few red flags on that because of your fiduciary responsibility to your seller. So the question was raised, if the buyer puts a $5,000 earnest money deposit down for your listing, your contract, and the buyer says, I want it held at ABC Title Company. The money goes into ABC Title Company, and ABC Title Company inappropriately uses or negligently loses that escrow money. Then has the real estate broker breach their fiduciary duty to the principal, to their seller in that example. And the answer is yes, they have, absent some additional contract language. And here's the reason why. The title company has no guarantee fund. So the money is absolutely lost to both the buyer and the seller if the title company negligently or intentionally misuses those monies, and the money's gone. And you can see it in its real meaningful way if you had a $50,000 deposit and the money's just gone, right? And the title agent is arrested, and whatever the case may be, doesn't matter. They inappropriately use the money and it's gone. They can go to jail all day long, but that doesn't help your transaction. That doesn't help your buyer. It doesn't help your seller. So what happens in those instances is the money cannot be recovered. If the same thing happened, but the money was being held by a real estate broker, and the real estate broker that was holding the money misused it negligently or intentionally misused the funds and they were gone, and trust me, it's happened many, many times, then can the buyer and the seller recover the money? Does anybody know the answer to that? If a earnest money deposit is misused, lost, stolen, the broker, real estate broker, loses the money somehow. They buy a boat, they go on vacation, whatever they do, they use the money and it's gone. Can that money be recovered if it was held by a real estate broker? And if so, how? Does anybody know the answer to that?
I'd say that it can be, it can be recovered. They would just have to, I guess, take them to court.
Okay, you're partially right. Let's just say, yes, you can recover it, but you don't have to go to court actually to recover it. The real estate brokers are required, all of us actually as real estate agents, anybody in the real estate industry, are required to participate in the guarantee fund, right? Everybody knows about the guarantee fund with the real estate commission. So if a broker misuses or steals monies on behalf of clients, escrow monies, the money, a claim is made before the Maryland Real Estate Commission, and all the money is put back by the Maryland Guarantee Fund. If a title agency misuses or steals the money, there's no guarantee fund. You can't go to the guarantee fund and get the money. You can't go to the Maryland Real Estate Commission guarantee fund. So now your client, if the monies are held at a title company, loses all of their money if it's misused. But if the monies are held by a real estate company, the monies are protected by the guarantee fund up to $50,000 per claim. So if you're the real estate agent who's looking at a contract, where would you want the escrow for your seller or buyer to be held? At a title company or at a real estate brokerage? Well, let's suppose that you are the agent involved in the contract that says that the money went to a title company, and then the money is gone, and then the buyer and the seller decide, what the hell, this money's gone, and it could have been recovered if the money was held by a broker, but nobody said anything about the monies not being able to be recovered if they're held at the title agency. Now, do you have exposure? Yes. Do you have absolute liability? Not sure yet. No cases have actually gone gone before the courts that I'm aware of at this point to hold a broker liable in the event that the title company misused or fraudulently commingled escrow funds. Is there a potential claim against a broker for negligence? Potentially, yes. You didn't participate in the actual theft of the money, but the negligence claim could be there on the basis of the fact that there was a place to put the money where the buyer and seller would be protected, but the parties chose another place because they wanted convenience for the broker, not because they were looking out to protect the seller or buyer. And so in that context, you understand the fiduciary rule is the rule of protecting your buyer before yourself and your own convenience. Well, I know there's a couple of bigger brokers that are always saying, put it to the title company, put it to the title company. I just don't know of a case yet before Maryland where it's been tested. So I imagine that's going to come around pretty soon. Anybody want to comment on that? Shay and Jasmine, I know I think I remember having some discussion about this when it was first started, I think, but I had a mini discussion, so I could have been just confusing who I was talking to. But what is your policy, if any, right now at Porterhouse? How do you guys handle that? Well, we'll come back to that because I'm not sure if they can actually pick up on that. But each one of you will make a decision on that when you see your contracts come in on how you want to do that.
Can you guys hear me?
Oh, now we got you.
Can you guys hear me now?
Yes.
All right, perfect. So our policy is that we hold escrow in-house for all of our clients, just so that we are performing in our fiduciary for just accounting, so that we're able to account for our clients' money there. And we'll talk a little bit more the next time because we're going to go ahead and wrap it up. This has been amazing, so I didn't want to stop us. We're a little bit over time.
Well, way over.
As
Sorry,
it pertains
guys.
to no worries, you were going and that was great. So I did not want to interrupt the flow. That was some great information there, and we have a lot more still to cover. So we're going to have a part 2 and likely a part 3 of this as well. But Porterhouse's policy is that we keep all of our clients' escrow in-house, because I know you've taught before, Glenn, with regards to title companies, it only requires one party signature in order to release that money. And our clients' money is more secure with a real estate brokerage than with the title company.
Correct.
All right.
Yep.
So we're gonna wrap it up there for today and open up the floor for questions. And you can wrap it up for everybody, Glenn, and see if they have any questions.
I'm happy to do so. And sorry, guys, I tend to talk long, so my apologies. I get into this meat of this stuff, and I love real estate. So yeah, so cut me off whenever. Nonetheless, anybody have any questions? Is there anything out there up to what we've gotten through today, which let's just call it, paragraph 17, 18. Some of the stuff is going to be pretty quick to get through on our second go around. But does anybody have any questions that they'd like to throw out? I'm happy to answer.
Yeah. Hey, Glenn, I don't have a question for you, but I do want to just say thank you again, because it's been very informative. I got a lot of notes from the discussion today. You covered a lot of things. And like I said, it's a lot of questions that I did have, they were already answered during your presentation. And I just, again, say thank you.
Thanks, Matthew. I really appreciate it. I love what we're doing here. It's good stuff. And it's great to see people, and Porterhouse has been, like this since the beginning, who take a great interest in what they're doing. So top professional marks. Good job. Thanks. So Jasmine, I guess that's it. So if you want to, take it from there, guys, it's Curtis, as always, good seeing you. Matthew, thanks again. And everybody else who's on, hope you got something out of today. And of course, I'm always open for calls or emails or texts or whatever. Shane, Jasmine have all my contact information if you need anything. And that's it for me today. I'll talk to you guys real soon, and we'll hopefully get back to a normal real world meetings sometime in the near future.
Always a pleasure.